Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Elloian. Our show topic today is corporate personhood, how big business, big money, and politics is hijacking the U.S. Constitution. Our guest is Attorney Shanna Cleveland. She is Senior Counsel at Free Speech for the People, an organization devoted to renewing our democracy and taking big money out of corporate interests in politics and stopping misuse of the Constitution by corporations. She has been senior attorney for a number of political and environmental organizations, including the Conservation Law Foundation, where she worked in climate and clean energy. She has received awards, including one presented by our former Massachusetts State Supreme Court Chief Justice for her work on access to justice. She graduated magna cum laude from Harvard College and earned her J.D. from the University of Virginia Law School while serving as executive editor of their law review. She received her Master of Laws degree, magna cum laude, from Vermont Law School. Let's welcome Attorney Shanna Cleveland. Welcome, Shanna.
Yeah, it's great to be here with you.
Same here. Now, corporations are hijacking our constitutional rights. Tell us about that.
Yeah, so really what we are witnessing is a brazen assault on the U.S. Constitution from some of the largest, wealthiest multinational corporations in the world. And I wish that it were an exaggeration to say it, but one of the Harvard Law professors who works on these issues has called it an all-out corporate takeover of the First Amendment of the Constitution. And so what we're seeing is that although there's been this long struggle in the history of our nation by corporations to amass more power, it really has accelerated since the rulings in Citizens United and Hobby Lobby expanded the rights of corporations and also emboldened corporate lawyers to make arguments that would have been considered fringe or frivolous arguments only a few years ago. And a couple of real issues with that is that one, it's taking fringe legal arguments and injecting them into the mainstream conversation.
Let's talk about some of those fringe arguments and what they entail and what types of cases those are in.
Sure. So they're really taking or making an attack on some of our most dearly held and hardest fought for constitutional protections, like the First Amendment and the 14th Amendment. And what they're doing is essentially arguing that corporations are just as disadvantaged or have been just as oppressed in some cases.
Discriminated against?
Just as discriminated against as individuals who were initially intended to be protected by the First and the 14th Amendments.
That seems like an inane argument.
I think it would make most first-year law students who had just taken constitutional law blush to be put up in front of a court and asked to make some of these arguments. But because of the massive concentrations of wealth and power that corporations have, they feel pretty immune and privileged to go into court and make these arguments. And even when they lose, they are still kind of pushing the envelope and changing the way that people think about these issues in the mainstream.
They're changing the paradigm.
Exactly.
Now let's talk about the First Amendment and free speech. From what my understanding and my own research, I found that free speech is not only the right to speak, but the right not to speak.
That's right. So one of the key areas where corporations have launched this attack is really in the First Amendment realm. And what you often see is corporations like multinational pesticide producers, or you might see dairy farmers who are putting growth hormones in their cows, arguing that the government cannot make them label their products to say whether or not they've used recombinant growth hormone, or whether or not RGBH, or whether or not they haven't. So this was a case from Vermont where essentially the state and its citizens wanted to know whether or not these hormones were in their milk. And the company basically said, the government cannot compel us to speak. And they actually prevailed on that claim and were able to prevent a democratically enacted law from going into effect by using the First Amendment.
It seems counterintuitive because when you buy a product, you want to know what's in that product. And consumers have a right to know what's in their product, or else, most could have allergies or could have some kind of deleterious effect. If they say, for example, there's peanuts in it or something that would cause them harm. So from that standpoint, I can't understand why they would not want to speak, quote unquote, to inform a consumer of what is in that product.
So that's one of the key issues here that comes into play, is that when people are considering trying to work with their legislators or their local regulators to pass laws or ordinances to protect public health and consumer issues, consumer concerns, what they really need to make sure they're doing is focusing on talking about the particular public health harm or scientific evidence around the harms that the product could cause, and make sure that they don't let language of animus towards a company, ill will, creep into the conversations. And that's really one of the places where corporations have tried to make some hay.
And let's talk about the First Amendment as well as the 14th Amendment, on how that is making an argument in the corporate world about some of these issues.
Sure. So in the 14th Amendment context, what we're really talking about are equal protection challenges. And one of the things that's amazing about the 14th Amendment and the way that it's really been subverted here is that the 14th Amendment was about protecting freed slaves. I mean, some of the most vulnerable and marginalized among us. And really about righting some wrongs of the past and making the Constitution, making we the people in the Constitution apply to everyone.
Yes, it's about people.
It is. It's about people, exactly. And what is stunning is that even back in 1938, Justice Black, who had presided over a lot of the equal protection claims that had been brought to the Supreme Court, said that only 0.5% of 14th Amendment cases were actually being brought by by freed slaves or by the people that it was intended to protect, and over 50% of the cases were being brought by constitutions who were saying that they were persons who were entitled to the 14th Amendment protections.
You mean corporations
who were saying that they were in effect persons.
Yes.
Even though, from the beginning of the U.S., it's been clear that corporations are not people. They're
not natural people.
Fiction. They're not natural people. They're artificial people who are
created by law.
By law, exactly, and who are limited by the charters that create them.
The state charters that create them. But again, the 14th Amendment, I think it's been totally taken out of context here. And if I recall, Justice Powell was one of the first to put this in motion. Tell us a little bit about Justice Powell and who he was.
Yeah, so part of what's so amazing about this is that there are some stories that have been buried for far too long. So this hasn't happened by accident. Justice Powell was an appointee of Richard Nixon. And before Justice Powell was on the Supreme Court, he represented Philip Morris and was a lawyer for the tobacco industry and big business. And he was concerned about kind of the environmental revolution in this country, where we started putting in place regulations to protect the environment and people. And he drafted a playbook for big business to attack these environmental and consumer protections. And nobody knew that he had drafted this playbook when he was undergoing his confirmation hearings.
That's a major conflict of interest.
Exactly. And what's incredible...
That warrants disclosure.
It should have been disclosed. And I think certainly, in this day and age, people would recognize that is exactly the type of thing that ought to be disclosed when someone is being confirmed for a position on the court. But he didn't disclose it, and Philip Morris presented him with the robes that he would go on to wear on the Supreme Court as he was presiding over cases like this. And he really changed and brought back into the jurisprudence this idea of corporate constitutional rights, and expanded the notions of corporate personhood in a way that led to ultimately the decision in Citizens United that affected campaign finance.
Oh, so he really reconstituted this whole movement.
He did, and he gave that playbook to the U.S. Chamber of Commerce, and the U.S. Chamber of Commerce is, often among the plaintiffs or amicus friends of the court in these cases, but also they've given it to all of the big industry players, and that has been part of what has fueled this.
This seems like the whole paradigm here is not only shifting, but is tainted by some deceitful manipulations that were not disclosed many years ago.
Right, and by a Supreme Court justice who was appointed by a president who was later impeached. So there are a lot of interesting parallels here. That's not the only sordid history of this, though. I mean, there's a great new book out by Adam Winkler called We the Corporations. That's not my favorite title, but he talks about one of the first cases where a corporation argued that it should be protected by the 14th Amendment. And there was this character, Roscoe Conkling, who was a really big deal at the time, is what we would call him. He had been nominated twice to the Supreme Court. He had been confirmed. He decided not to take up that position because he was making too much money. And he stood in front of the Supreme Court and argued for Southern Pacific Railroad that as the only living survivor of the drafting committee of the 14th Amendment, he could tell them that they had initially planned to say no one shall deny any citizen equal protection of the law, and they changed it to person so that it would apply to corporations as well. Well, that was a complete lie, complete fabrication. He even created this musty journal that he said, confirmed all of these claims that he was making, but it turned out not to be true at all. And what we really see in a lot of these cases is almost this sleight of hand by corporate lawyers and manipulation in order to undo really the democratic process.
So, okay, moving on from there, though, let's now go to what's called the dormant commerce clause, or the negative commerce clause. I think most people have never probably heard of this.
Right, exactly.
Let's talk about the effects that is having in this area of the law.
Yeah, so, I'm trying to think of some of the most high profile of those cases. I mean, really what this was intended to do was prevent one state from discriminating against corporations or individuals in other states.
In interstate commerce.
And so you've got some of the big ag corporations who are trying to deploy this to protect themselves from states who want to develop protections for family farmers. So really, you have here family farmers pitted against, big multinational ag companies. And the multinational ag companies are coming in to argue that they're being discriminated against by state regulations that were put in place to help the farmers.
Let's talk about some cases that have exhibited some of the issues that we just discussed, the First Amendment, the 14th Amendment, and some of the Commerce Clause and issues.
Sure. Well, we talked in the First Amendment context already about compelled speech. Let's talk about this other argument that's been raised recently in a high-profile case. So Exxon is in a heated battle with the Massachusetts Attorney General and the New York Attorney General. And they're under investigation for claims that they may have committed either securities fraud or consumer fraud. Well, instead of cooperating in those investigations, Exxon decided to play offense. And what they did was really unprecedented. They filed suit against the attorney generals, and they claimed that they're the victim of viewpoint discrimination.
And what is that?
So essentially, one of the concepts around free speech is that you should be entitled to speak your voice and not be discriminated against for the viewpoint that you're espousing. And so what they've said is, it's not that what we have claimed about climate change is false, it's that the attorney generals don't like what we've said about climate change, and that's why they are trying to come after us. And by investigating us, they could chill our free speech or our right to free speech because they're going after our viewpoint, our disfavored viewpoint.
Isn't it true, though, that there were documents that were obtained that showed that Exxon, I believe, is one of the companies that's in litigation, had access to information that actually substantiated the climate change was real and was a problem?
This is what's crazy. So Exxon has had documents internal to the company since the 1970s that talk about the impacts of climate change, the contribution of fossil fuel burning to climate change, and really has known about the state of climate change throughout. But publicly, they have tried to muddy the waters in terms of what is and isn't understood about climate change and its impacts. And so that's really, if you think about it, a garden variety case of securities fraud, when you know one thing internally in the company and you tell people that you're trying to get to purchase your stock another thing. That's fraud. The First Amendment doesn't protect fraud. But what Exxon's trying to do is say, well, look at us. We're just a little company who's trying to, voice an unappreciated opinion about the state of climate science, and we're being attacked for it.
Even though they're lying.
Even though they're lying. So fraud doesn't, or the First Amendment doesn't protect fraud. And they're essentially lying and trying to use the First Amendment to protect them.
They're lying about their own research, and they're lying to their shareholders.
Right, and they've basically misrepresented to consumers what the impacts are of using fossil fuels.
As well as the EPA, I would assume.
They certainly have done plenty of lobbying that would indicate that they're saying to regulators things that internal documents would disagree with.
So what stage of litigation is this case currently in?
So here's the thing. One state court has dismissed Exxon's claims just out of hand. They're ridiculous. The Southern District of New York recently dismissed Exxon's claims, called them a wild stretch of logic, implausible, and based on extremely thin allegations. But Exxon, who has somewhere around $42 billion in profits, a
little company.
A little company. They are claiming, because they have all these resources, even though they were slapped down in no uncertain terms by the district court and the state court, they're going to appeal it. And not only are they going to appeal it in the Second Circuit in the existing case where they're trying to prevent the investigations by the highest law enforcement officials of two states, they're also going to start making this argument in claims that have been raised against them by towns and cities who have been damaged by impacts from climate change. So the city of San Francisco, I believe city of Marin or San Mateo, a few other cities, Boulder, have brought suit against Exxon for some of the damages that they've undergone, wildfires, flooding, etc., as a result of climate change. And Exxon appears poised to make the same argument about First Amendment rights.
So their defense is the First Amendment, not that they were lying?
not that what they were saying was true. Yeah, exactly.
Was untrue.
Yeah.
Untrue to the stockholders and untrue to the American people.
Right.
It seems unfathomable that this kind of dereliction of duty to their own shareholders and stockholders and is going on at an unprecedented rate.
Yeah, what's incredible is, for Exxon, it's one thing if it were, just a public outcry, but it's also their shareholders. 62% of their shareholders voted in favor of a resolution last year at the corporate meeting calling on the company to put out a report on the risks of climate change. They see this as something that affects the bottom line of the company, the value of the company, and that investors ought to be informed about. And so Exxon's not just bucking public opinion, they're bucking shareholder requests, and they're also really mischaracterizing how it is that they've used media. They've used contributions to particular academics, contributions to nonprofits that are think tanks that are funded by the American Petroleum Institute to really try to make what is certain in climate science seem uncertain.
Well, we certainly have a plethora of those deniers in the current administration. And I was wondering, was Rex Tillerson at Exxon when some of this actually started, this litigation began?
He was, and actually he's been at the center of a lot of Exxon's statements about climate change. And Tillerson has, on the one hand, acknowledged that climate change is real, and on the other hand, tried to claim that it's really a policy discussion about what that means for the economy, for the U.S., for the world. One of his famous quotes at the shareholder meeting where investors voted on a climate resolution was that humans have a great capacity for adapting to adversity. So he recognizes, in some sense, that climate change is going to cause significant social dislocations, population movements, and unrest. But he's only concerned about the profits for his corporation because it's a corporation, not an association of people.
Now, isn't there also a Fourth Amendment argument that's being made too about seizure of corporate documents?
So there has been, there is a bit of a distinction between things like the First and the 14th Amendment, where you're really talking about rights that can only be exercised in some sense by individuals or individual liberties, and when you're talking about the Fourth Amendment and you're dealing with property, right? So corporations do own property, and they have tried to use the Fourth Amendment in some cases, but courts have not gone as far as they have been willing to in the First and 14th Amendment context with the Fourth Amendment cases.
Yeah, I noticed that some of the cases that I briefly took a look at, I was appalled at, people who have been discriminated against and the type of scrutiny that entails. I think most people don't know that in our jurisprudence there's levels of scrutiny. The highest scrutiny, the mid-level scrutiny, and the lowest level scrutiny. Right. And traditionally, discrimination against minorities and people of color has gotten heightened scrutiny. Mm-hmm. And where are we, on that realm, where are we now with corporate jurisprudence on those levels of scrutiny? Right.
So technically, in terms of the level of scrutiny that some of these corporate claims should be getting
by our courts
under the 14th Amendment or any of the other constitutional claims, is a rational basis review. But what they've done is
which is low-level scrutiny.
Which is low-level scrutiny. But what they've done is they have taken cases like Romer v. Evans, which was about a class of people who had historically been oppressed, who had suffered, being targeted for beatings and murders and all sorts of horrendous restrictions and regulations. So it was intended to protect gay people in the LGBT community. They took the arguments and the decision of Romer v. Evans and have tried to say that they are being subjected to invidious discrimination or to disfavored treatment because of a community's animus towards them. So there was a case in Missouri where a coal company essentially was arguing against a ballot initiative that would have removed tax breaks that the coal company got. So here we've got a coal company that's been getting handouts from the government, subsidies for decades, and they are claiming that by removing that subsidy, they are being discriminated against because the people in the town want to favor renewable energy over fossil fuel energy. And, you know, unfortunately, in that case, you had a judge who was willing to take that. I mean, the idea that a major multinational company, in this case Peabody Energy, Peabody Coal, which is was one of the largest coal companies in the world, ended up financing the plaintiffs. And so there was a clear connection there. But they're claiming that they've been oppressed and discriminated against in the same way that a marginalized community like the LGBT community has been discriminated against.
It's just counterintuitive. It seems like I said, an inane argument.
Right.
But they have
It's really shameful. I mean,
it is shameful.
It is.
But they have gotten some traction, which is even more worrisome.
Right.
And I see parallels here with big tobacco and what we went through with big tobacco.
Yeah.
And this seems like they're taking big tobacco to the next level.
Well, think about it. I mean, that's where Lewis Powell came from, right? He came from Philip Morris. He came from big tobacco. He wrote this playbook that ended up being used by big tobacco, among others, and is now being deployed by a lot of companies in the environmental space. So this is really, you know, this didn't happen by accident. It is a well-coordinated, well-financed campaign.
Effort. So where do we go from here? What can people do if people want to, you know, take a stand and say, you know, I really think this has gone too far. You know, Citizens United has given them more oxygen, has given them more ability to do some of these things with big money in politics. What can people do who say, you know, this has got to stop?
The good news is there are a lot of opportunities for action on this. First, one of the reasons my organization was founded to begin with was to overturn Citizens United. So there are ways to get involved in working on a constitutional amendment that would overturn it. But there are also litigation strategies that are out there that people are working on. And there's also the court of public opinion, which is in some ways the most important court. So working with organizations who are focused on reining in corporate overreach is one great way to get involved. But what we really focused on in this new report that we released called Contaminating the Courts was reaching out to environmental advocates, because a lot of people are attuned to the corporate personhood arguments in the political sphere, but they haven't really noticed it in the environmental area. So what you can do in those cases is be prepared when you're getting ready to try to pass a new ordinance or a new law that covers an environmental issue. And know that as you're developing the case for whatever the regulation is or ordinance, you want to make sure to be focused on the public health impacts, the environmental impacts, the true objectives behind the regulation, and don't let, you know,
animus.
Don't let anything that looks like animus slip into your conversation, even though it might feel satisfying to say.
Yes.
It's about the impact on the public and on communities. So that's one key thing. And then I think another thing that people can do is really talk with people in their community, talk with their neighbors about the fact that corporations are not people. And we can't let them.
And they may not be your friend.
And they're definitely not your friend.
Maybe or may not.
We need to remember that right now, corporate law sees corporations' primary purpose as providing profits and value for shareholders. And so we need to remember that when they come in making claims about their individual liberties being violated.
As just an aside, I just want to say that Massachusetts was the 11th state to adopt the benefit corporation. So corporations that are really intrinsically interested in benefiting people, planet, and profits can do so.
Exactly. And there are many nonprofit corporations. I mean, I work for a nonprofit organization that are doing great work. But the problem we're talking about here is of course, some of the larger corporations that essentially don't want to comply with long-standing securities laws, environmental laws, and consumer protection laws.
The companies that put power over people.
Right.
Well, thank you. This has been an enlightening discussion. I want to thank you so much for being here. and we'll have to continue the conversation another time.
It was great to be with you.
Thank you. I want to thank our guest, Attorney Shanna Cleveland, for sharing her insights and opinions on the law, political history, and the environment. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guests, visit The Legal Edition online at thelegaledition.com. As always, this information is for general educational purposes only. It is not to be construed or relied upon as professional or legal advice, and please consult a qualified practitioner as to your legal, business, or professional needs. And don't forget, subscribe online, follow us on Facebook, YouTube, and Twitter.